I'm going to start by telling you two things that I tell every single new patient that I meet. The first is that I'm going to speak very frankly about the topic today. We're going to talk about death and dying, and we're going to talk about assisted dying, and I'm going to use those terms, and I think with this audience today that shouldn't be a problem or an offense in any way. I'm also known to speak very fast. I am aware of that. Some of you might think I actually have an accent, which is beyond me, but if I am actually speaking too fast or need to repeat something, somebody on the screen can just wave at me and I won't be offended. That's not a problem. I guess I don't want to waste a lot of time on myself. We have very limited, valuable time today. I just want to put in the context of why it is that I'm actually speaking to you as opposed to somebody else. I am trained actually as a family physician, a little bit different than a general practitioner, but I spent most of my career focused on maternity and newborn care. Our law did change, as Trevor mentioned, in 2016, and I pivoted to end-of-life care at that time. I now spend 90% of my clinical practice in assisted dying and work in MAiD. And I have had the privilege of speaking to a large number of people about their end-of-life options, specifically about assisted dying. And I've had the deep honor to assist a great number of people to end their life. If there's time and interest later, I'm happy to discuss with you why I think this is some of the most rewarding work of my career. I do have a lot I want to say today. I'm going to pack it all in just over half an hour. I've kind of divided up my talk today in three main sections. I'm going to first talk about how we got here, especially here in Canada, how we got to this place with assisted dying, especially without a particular parliamentary will to enact law, as Trevor mentioned. I'm going to speak about how things have evolved since our law has come into place. And I'm going to talk a little bit about where we might be going. I'll just pre-warn you that I'm going to spend a slight majority of the talk on how we got here. I think it's important. I don't want to get bogged down in any details, anything specific to Canada, but I do want to have enough of a broad overview at the beginning so that we can inform our robust discussion afterwards. I think if we have that base, then we'll be able to have a better discussion. So that's my plan. And I always start my talks with a little basics because I really appreciated it when I first went to my very first conference on this topic. So just to say some of the terminology, if I talk about an assisted suicide, I'm talking about the prescribing of a lethal medication to be taken by the patient. So in my context, I see a patient, I assess them for eligibility, I write the prescription, I give them the medication, and they self-administer it. These are not terms we really use in Canada, but I know a lot of times in many jurisdictions, people talk about assisted suicide. When I talk about a voluntary euthanasia, what I mean in a Canadian term would be a clinician-administered death. So it's the administration of a lethal medication by a healthcare professional at the explicit request of a competent adult. And so the real difference between these two terms is who administers the medication. What I want to point out to you today, what's important in our conversation, is that both of these are available in Canada. And we have an umbrella term called medical assistance in dying, which I will now refer to as MAiD, which covers both of these possibilities. And in Canada, we're allowed to administer this care if we are a medical physician or a nurse practitioner. And I'm pretty sure that we are the only jurisdiction globally where nurse practitioners are able to do this. So when I talk about assisted dying, this is what I mean. I'm talking about MAiD. Because we have all of these options available to us, we have joined an exclusive club globally. You will not be surprised to know we have joined the Netherlands, Luxembourg, and Belgium in this offering. Everywhere else, as you are probably aware, every other jurisdiction in Switzerland, in those few United States where this is allowed, in some areas of Australia now, they have assisted suicide available, but not the other. So just to clarify what we're talking about. So really, I want to dive right into how we got here. I'm going to start my story in 1972, which was the year in Canada that suicide was decriminalized. Of course, when that happened, anybody who was assisting in the suicide in any way was still liable to be charged and liable for up to 14 years in prison. And that hasn't changed, actually. But 20 years later, many of you will be familiar with the name Sue Rodriguez. Sue Rodriguez in the early 1990s was a young woman in her early 40s when she was diagnosed with amyotrophic lateral sclerosis, otherwise known as ALS, sometimes referred to as Lou Gehrig's disease. And many of you will know this is a progressive neurological neurodegenerative disease that was certainly going to be fatal for her at some point. Sue did not want this disease to be the deciding factor in how she would die or when she would die. She wanted very much to have control over the end of her life. And so she asked for a physician to assist her. That, of course, wasn't legal in our country, so she went to court to fight for that right. Sue came to the national headlines, really, and an international audience when she made a video statement that she presented to the Canadian Parliament. And she made her famous quote, where she said, "If I cannot consent to my own death, whose body is this? Who owns my life?" And it really attracted a lot of attention. She took her fight right to the highest court of our country, which is the Supreme Court of Canada. And many of you will know that she lost this fight in a 5-4 split. She was unhappy with that decision and did ultimately 4 months later take her own life with the help of an anonymous physician. That incident was investigated, but no charges were ever laid. But most importantly, what Sue Rodriguez did, other than show us her tremendous courage, is that she kicked off truly a national debate on the topic of end-of-life care and assisted dying in particular. These were dinner conversations across the country. There were national panels that were convened. There were a number of high-profile court cases that then happened over the next decade or two, not necessarily about assisted dying, but in related cases. Mostly about the withdrawal of treatment and things like that. But it really kick-started the conversation. And to the point that 20 years later, the zeitgeist in the country had probably changed. In fact, so much so that another challenge was launched. And in 2011, 2 other very courageous women made a similar challenge. So Kay Carter, so you know, was an 89-year-old woman who had a non-terminal illness. She had a diagnosis of something called spinal stenosis, which is, again, a progressive and painful condition. And in Kay Carter's case, it was it was causing intolerable suffering for her. In fact, Kay Carter did not want to wait for legal action. She actually traveled to Switzerland in 2010 and had an assisted death in Switzerland. But Gloria Taylor was a 61-year-old woman who was also diagnosed around the same time with ALS, the same disease that Sue Rodriguez had. And she also similarly felt that she wanted control at the end of her life. So Gloria Taylor joined with the daughter and son-in-law of Kay Carter, and they joined with an organization called the BC Civil Liberties Association to challenge essentially the same law in Canada, which has a blanket criminalization of assisted dying. My picture here shows you the big black box. In fact, it is in our criminal code that assisted dying is illegal in this country, and they wanted to challenge that. I'm going to take a very little sidebar here just to put in a very important Canadian context, which is that we have something called the Canadian Charter of Rights and Freedoms. So the Canadian Charter of Rights and Freedoms is a constitutional document. It was developed and put in place in 1982, so not that long ago. And it's with this document that both Sue Rodriguez and these women, Taylor and Carter, were to challenge the blanket prohibition of assisted dying. The Charter actually outlines the fundamental freedoms and democratic rights of all citizens, and that includes the right to life, liberty, and the security of persons. Interestingly, what the lawyers did I'm going to refer to this as the Carter case, as it's colloquially known. In the Carter case, the lawyers actually argued that Gloria Taylor was facing a cruel decision, that she was soon to become disabled due to her illness. And if she were to have control over the end of her life, she would need to do so earlier on in her disease than she might have preferred. Because she was going to lose the ability to control her own destiny after the disease progressed to a certain place. They in fact argued that because of this, because of the prohibition against anyone assisting her to end her life, that her right to life is actually being infringed according to the Canadian Charter of Rights and Freedoms, which seems like a kind of a backwards argument to many, but it's quite clever, quite creative. And in fact, it worked. I'm going to actually read you the quote that one of the judges wrote at the final decision at the Supreme Court level of Canada, where all 9 justices decided unanimously to strike down this blanket prohibition against assisted dying. And he wrote, and I love this quote, he said, until this decision, he said, "It is a crime in Canada to assist another person in ending her own life." He says, "As a result, people who are grievously and irremediably ill cannot seek a physician's assistance in dying and may be condemned to a life of severe and intolerable suffering." A person facing this prospect has two options. She can take her own life prematurely, often by violent and dangerous means, or she can suffer until she dies from natural causes. The choice is cruel. And with that, they struck down the blanket prohibition of assisted dying in Canada. It's quite a remarkable decision. At that point, I should tell you, the Supreme Court does not have the power in our country to mandate that Parliament do anything. But they did strongly suggest that Parliament make a law to regulate what happened. What the Carter decision decided, what was written in that decision, were the criteria that were carved out within the black box where an assisted death could be offered without criminal liability. And we call these the Carter criteria. These criteria in this decision were written ultimately by a constitutional expert in our country, by the judge, and she outlined the 3 or 4 basic criteria that needed to be present. The person needed to be an adult over 18. They needed to be competent or capable of making their own healthcare decisions. They needed to have a grievous and irremediable condition, which was cited at the time as a serious illness, disease, or disability. And they needed to be suffering intolerably. And that was it. That was the Carter criteria. And you'll notice specifically, there's no allusion to terminality in these criteria. There's no necessity of prognosis being at any particular limited amount. So that was important. The courts then gave the government a year. This would not come into effect for 12 months. And the government was supposed to spend that time crafting a law that would regulate this practice. I will save you the political story of what happened during that year. Safe to say there was a national election. We had a change in government. They asked for an extension in time. And ultimately, in June of 2016, this was to become legal. And in fact, on June 17th, 2016, we had a new law. The bill was called Bill C-14 that then became law. So we still refer to it as Bill C-14. And you'll notice my green pentagon is substantially smaller than the blue square within my big black box. And that is on purpose. That is because Bill C-14 is, in fact, more restrictive than the Carter criteria. Let me just take a moment to tell you what's the process in our country. I would point out that this was brought by a courageous patient on the basis of a charter challenge based on her rights to the right for life. So this is a patient-centered care, a patient-driven care. So in the process of assisted dying in Canada, if you want to have an assisted death, you must ask for it, and you must be the one to ask for it, and nobody else can ask for this on your behalf. You make a request that's not verbal, but it's in writing. The written request must be, I'll just tell you briefly, must be witnessed by 2 independent witnesses. You must then have a 10-day waiting period, a reflective period, to make sure that your wish is enduring. And these are all safeguards built into our law. Once that happens, then we need 2 clinical assessments by either a physician or a nurse practitioner. These must be independent assessments. And if they both agree that you're eligible for care, you may then plan an assisted death. The capacity to make this request must be present when you fill out your form requesting this. And the capacity to make this request must be present and given immediately prior to the administration of medication. So we require a final consent. And these, again, are all safeguards built into our law. So that's a very brief outline. Patient makes a request, it's written, it's witnessed, 2 independent assessments, and then consent given finally at the end. That's how the process fundamentally works. I'm going to spend a real 5 minutes, or hopefully a few less, just explaining our law, not to get into the details of it, because I could spend probably an entire day speaking about each one of these. But I think, again, it's important you understand this just at this level so that we can have our fulsome discussion. So to be brief, there are 5 criteria that must be met in order to have an assisted death in Canada. And they are as follows. You must be an adult. You must be 18 years of age. There's no 17 3/4. Number 2, you must be eligible to receive Canadian health care. That doesn't mean you must be a Canadian citizen, but it does mean you can't come from another jurisdiction out of our country into our country and pay privately for this care. That is not allowed, that is illegal, and it's obviously meant to deter against what some people refer to as death tourism. We're not interested in that here, and I don't think this will ever change in our country. The 3rd criteria that must be present in order to have an assisted death is that you must make a voluntary request. And by voluntary, I mean that there's no sense of coercion. So nothing obvious, no external sense of coercion, not from an angry spouse, not from a greedy child who wants the house, not even subtly from a physician who throws up their hands and says, I have no more treatment for you. I don't know, I got nothing more, and sends you home. That is still a subtle form of coercion in some cases. It's my job to make sure that the request is actually voluntary by the patient and aligns with their values and what they truly wish. The fourth criteria for an assisted death in Canada is what we call a grievous and irremediable condition. And here it differs significantly from the Carter decision. So in our current law, which I will point out, Bill C-14 was the original law in Canada. It is still to this day the law that we work under. It has never changed, despite what some people have suggested in other jurisdictions. It has never changed. The safeguards have never changed. We are still functioning under the same law. And this law outlines what a grievous and irremediable condition is. And it says that you must have 5 other criteria present. And all 5 must be present, or you do not have a grievous and irremediable condition. And what are they? They are that you have a serious illness, disease, or disability. I think that speaks pretty much for itself. The second criteria is that that serious illness has put you in what's called an advanced state of decline in capability. What does that mean? Well, it has come to mean, we've come to understand, it means not that your disease is in an advanced state, but that your decline in function is in an advanced state, meaning you're no longer functioning in the way that you did before your illness. Often this refers to mobility and ability to function on your own, but it is personalized to each patient. That advanced state of decline must be considered irreversible or irremediable by any means acceptable to the patient. So that's the third criteria. The fourth criteria for grievous and irremediable condition is that the patient is suffering in a way that they deem intolerable. Now, suffering, of course, is a very personal event, a personal experience. So this is generally determined by the patient, and it's only the patient who can determine how much of the suffering they can endure before they deem it intolerable. The fifth criteria, the big debate, of course, is that the natural death of the patient is what's considered reasonably foreseeable. And yes, I don't know what that means either. So reasonably foreseeable is clearly an attempt by our lawmakers to nudge this law towards some sense of an end-of-life regime. Clearly, the Carter decision did not intend that. Clearly, this law did. And clearly, it's vague enough that nobody really knows what the intention was. I could literally speak for a very long time about the clause of reasonably foreseeable. I've spent many a week, weekend, and month debating this. I think the question really is who decides what it means, who should enforce what it means, and how do we do that? I'm going to leave that for later in our discussion, but those are the 5 criteria necessary for a grievous and irremediable condition. The 5th criteria necessary to have an assisted death in our country is that you must have the capacity to make this request. You must be able to give an informed consent at the time of your request in writing and at the time of the death. And by informed consent, I mean that you understand what you're asking for, you understand your illness, you understand your treatment options, you understand what palliative care is available, you understand what an assisted death is and what happens if you have one, and you understand what happens if you don't have an assisted death. If you have all of that information and appreciate your situation and articulate a request to die, that is an informed consent, and that's what I'm looking for in capacity. So these are, very briefly, all the criteria, the eligibility criteria for assisted death in Canada. Okay, I've given you a lot of information so far. So that's how we got here. Now, once Bill C-14 was introduced, 3 things happened at the exact same time. Number 1, people noticed that reasonably foreseeable was in the law, and many people said right away, that is not constitutional, that is not in line with the Carter decision, and they challenged that. Immediately, there was a court challenge raised in the province of British Columbia, known as the Lamb case, coincidentally. We'll talk about that later. And later on, a couple months later, a similar challenge was launched in Quebec called the Truchon-Gladu case. And again, we'll talk about that in a moment. At the same time, we recognize that within the legislation for Bill C-14, there was mandated a review of the law and how it was going to be administered and how the rollout went, what's working and what's not working, mandated review in 5 years. In fact, in the 5th year of practice, as it says. And you'll all be interested to know that that 5th year of practice begins on June 17th, 2020. So we are looking at the doorway of our official review any moment now. The third thing that happened at the exact same time that the law came in is that there were 3 particular topics that the government explicitly said, we are not dealing with these situations. We're going to put them to the side and study them separately. And those 3 topics were the issue of mature minors, whether anybody under 18 could ever access this care, the issue of psychiatric illness as the sole underlying condition for the application for MAiD, what we would have to do potentially to safeguard that situation. Would it be the same? Would it be different? What we need to know about that situation. And the third situation that was pushed to the side was the issue of advance requests. So specifically, the example people mostly talk about is you're 70 years of age, you get a diagnosis of early dementia, and you say in that moment when you have capacity, oh, this is terrible for me. If A, B, and C ever become true, I would like to have an assisted death. Even if I've lost the capacity to say so, I'd like to make an advance request for that. That is explicitly not allowed in our law. Advance requests are not allowed in our law, and so that is something else for us to be looking at in the future. Okay, now you know how we got here, what our law says, and what happened. Now we go to how has it evolved? Just checking the time. Okay. Well, what happened next? I can tell you that very few physicians stepped forward to do the work initially. There were some all across the country, but very few. And as the law was less than spectacularly clear, that lack of clarity led to a certain element of conservative decision-making. There was a fear amongst those of us who did this work that we didn't know how aggressive the judiciary would be. We didn't know what their mood would be, whether they would be combing over every case carefully, looking for an example to make. Nobody wanted to be held up in court or on the front page of a magazine with jail bars in front of our faces. We were all quite aware of the fact that if we did this wrong, we were looking at 14 years of jail. And at the same time, we felt strongly that this needed to be applied and accessible to Canadians. So that lack of clarity, I would say, that sense of conservative decision-making, even so amongst ourselves, and also we sought out legal opinion and legal advice, of course, which was even more conservative than our own clinical decision-making, as that is their job to protect us. I think that this probably led to a significant diminishment of access to Canadians, to be honest. Having said that, there were those of us who stepped forward to do the work, and as we started doing the work, we began organizing and witnessing some extraordinary events. So there was a bit of the dichotomy going on. We did look towards some leadership. We looked towards the Canadian Medical Association for some guidance, for some support, for some training, perhaps. This was all very new. The Canadian Medical Association, in retrospect, I can tell you did something very brave, although at the time I didn't understand it. Many of you will be aware that most medical associations, certainly the American Medical Association, the British Medical Association, even the World Medical Association, and previously the Canadian Medical Association, have stated opposition to assisted dying. The Canadian Medical Association actually in 2014, when the Carter case was being heard, actually made a change and made a stated neutral opinion about assisted dying. This allowed them, they felt, to get involved in the debate and in the discussion, and most importantly, they felt it would allow them to represent the variety of opinions amongst their 90,000 members, near 90,000 members. So I think that was a very brave move on their account. But unfortunately for clinicians like myself, it meant that everything they did had to be somewhat balanced. So when they would offer a training session, there would be some element of training and also an ethical component about conscientious objection. And there was no real steady support for those of us who were doing the work, and we felt that nobody was representing us. In fact, we were a variety of doctors, primarily family physicians and palliative care docs, but also internists, anesthesiologists, and neurologists, and nurse practitioners, and nobody was really supporting us. Which brings me to a perfect segue about this organization. So at the Canadian Association of MAiD Assessors and Providers, I'm very proud to say I'm a co-founder of, and I am the current president of CAMAP. This group was literally launched in order to support the people that do this work, to have a more national voice, and to be able to enter the conversation. I do want to spend 1 minute telling you about CAMAP, because I don't think it's overly arrogant to say that CAMAP has played an integral role in the evolution of MAiD in Canada. And I think that this is one of the take-home lessons for any jurisdiction contemplating assisted dying, whether you're fighting for it still or actually implementing it. CAMAP really had 3 missions. I would just say that very quickly our group expanded to include not just the clinicians that do this work, but very quickly expanded to include all the people in the community that are involved in assisted dying. And this is a tremendously multidisciplined field. So we invite nurses and administrators and care coordinators and ethicists and social workers and pharmacists. All of these people are members of CAMAP at this point. We have three main missions. The number one is to support the assessors and the providers of this care. And we do that in a variety of ways, and I'm happy to talk about that later if you're interested in any way. We also try to educate the public, and most especially the healthcare community, about MAiD. There are a tremendous amount of myths and errors out there, so we try to rectify that anytime we can. And perhaps most importantly, or at least on par with number one, we are very proud to have taken a leadership role on determining what we hope will be the highest medical standards of care in MAiD provision. Again, nobody wants to do this poorly. There's very little evidence out there on how to do this work, and we realized jurisdictions like your own and others would be looking to Canada as a possible model. We wanted to do this as best as possible. And so we've been active in guidance. Okay, I'm going to take a small segue into data just so you have a sense of what's been going on in Canada since our law passed. There's been a tremendous amount of uptake, in fact. Health Canada supposedly puts out an annual report on the documented and reported cases of assisted dying in our country. They were very slow to begin that process, unfortunately. Bureaucratic reasons, I'm sure. They have caught up. But the most recent data was due out this month, and obviously COVID has delayed that. We do expect it over the summer. So the data I have actually been privy to from Health Canada tells me that as of December 31st, 2019, Canada has reported 13,712 deaths. Out of context, that means nothing. But it's not a tiny number. What I can show you is that through the years, every single year, the number of requests and provision of MAiD has steadily risen in Canada since our law changed. That is true across our country. We've had assisted dying in every province and every territory. We've had an increase in every province and every territory. We do obviously have pockets where there is less happening and pockets where there are extremely more happening. But in general, we see this rise steady throughout our country in the past 4 years. Gender-wise, just very briefly across the country, in every region, we see an almost equal access between men and women to this care. Age-wise, we see a wide variety. I apologize, this is an old slide. This scatter plot is actually not as wide as it should be. I have personally helped someone as young as 27. I have personally helped someone as old as 105. The average age across our country in the last 4 years has stayed fairly steady at age 74 years, and that really hasn't changed. The underlying diagnosis in assisted dying in our country, the vast majority, as we all expected, would be terminal cancer. The second most common underlying diagnosis is not neurological, as we thought it might be. It's actually what we lump together as organ failure. So end-stage disease, end-stage heart disease, end-stage lung disease, end-stage liver disease. If we put them together as organ failure, they're most common, second, and then followed by neurologic disease. Where is this happening? Again, this is old data from 2018 I'm showing you. Essentially, it's mixed between home and hospital, and it depends on the community that you're in. But certainly, we've all been providing MAiD in long-term care facilities, in assisted living facilities, in hospices, in palliative care units. I've personally helped people in hotel rooms. I have colleagues who've helped people in funeral homes, but the vast majority of people are either at home or in hospital, or anywhere I like to say is safe and legal. So how has this evolved? Well, I've mentioned CAMAP and our guidance documents that have helped standardize care across the country. In Canada, we have a unique form of federalism where our criminal code is federal and it takes effect in the entire country, but healthcare is actually administered provincially. So there are differences in different provinces and how this has been unveiled. CAMAP has noticed that sometimes that means differences in access to care, and we're trying very hard to make sure that the standard of medical care is standard across the country as much as possible. So our guidance documents have tried to do that. DWDC stands for a national advocacy group called Dying with Dignity Canada. You may be very familiar with them, colleagues of yours. They've been campaigning on this topic for over 30 years. They have been involved before, during, and after the change in law. They continue to support us as an organization, to support clinicians. They have a very large role in supporting the families and the patients. They do a very important role in telling the stories of the people who are involved, those who've been approved and those who've not been approved. And so we have an organizational evolution and support of the law. But what I really want to emphasize to you today is the role of patients, because patients have actually played a huge role in the evolution of MAiD in Canada. And that's my real other take home. I'm going to highlight two of them. One of them, just very briefly, is a woman I'm going to refer to as AB. Her identity is still a secret. This is a woman who was 77 years old who had osteoarthritis, a particularly strong form of osteoarthritis, where she was bedridden and riddled with chronic pain for many years. She asked for an assisted death, and to make a long story short, she was originally found eligible for the care, but her second assessor found her ineligible because they felt she met every criteria except for the criteria for her death being reasonably foreseeable. As a 77-year-old woman with osteoarthritis, it was felt that it was unclear whether her death would be reasonably foreseeable, and she was unhappy with that outcome and went to court for clarification. Again, I will save you the story of the court saga, except to tell you that the judge made two very important, very strong decisions in his verdict. Number one, he admonished both sides for coming to court to ask this question. He said very cleanly, very plainly, that the decision about whether a person is eligible for this care, and specifically whether their death is reasonably foreseeable, should not be decided by a lawyer and should not be decided by the courts, but must be decided by the clinician. It is the responsibility of the clinician to make that determination, and it is within their professional realm and expertise to do so. So it was a message heard loud and clear by those of us who do this work. That was helpful. And very importantly, he did an interpretation of the law where he pointed out that nowhere in our law does it say anything temporal about what reasonably foreseeable means. It does not say that you must be dying within 6 months or 1 year or even 2 years. In his interpretation, reasonably foreseeable meant that the patient was on a trajectory towards death. Now, on the day we're born, we're all on a trajectory towards death. That's not what he meant. He meant that on your trajectory of life, you then had a serious illness, disease, or disability, a grievous and irremediable condition which altered your trajectory, and now you are on a trajectory towards death. And that was the definition, really, of reasonably foreseeable. This is a very important interpretation. It allowed those of us that do this work to understand that's what it meant, although we suspected that's what it meant. It gave us a legal precedent to say that, and it gave us much more ease in widening who we were providing the care to. So originally, you can imagine when I might have seen a patient with, we'll say, Parkinson's disease, who was entering a nursing home, I might have felt clinically that they had several years left to live, but ultimately they would be dying from complications of their illness, and I wasn't sure if I could help them. Now, with the AB decision, I could see that they were clearly on a trajectory towards death due to their illness, and I could check that box off. They still had to meet all the other criteria, but at least it was clear what reasonably foreseeable meant. So this was very, very important, and again, due to the courage of coincidentally, female patient. I would also mention that patients brought clinicians to the work. Those who had long-standing relationships with their physicians who were very reluctant to get involved in the work, they went to their physicians and asked for this care and demanded this care. And although it wasn't quite so linear, it certainly brought more clinicians to the care than originally that we saw. I'm going to highlight very briefly one other person, Audrey Parker, another very courageous woman from Nova Scotia on the east coast of our country, was a 57-year-old woman who had metastatic breast cancer. And what's important with Audrey Parker is that she made her application for MAiD, and she was assessed for MAiD, and she was approved for MAiD, and then she wanted to set the date of her end of her MAiD procedure. And Audrey Parker was a person who absolutely loved Christmas, which sounds a little silly, but actually for her it was very important. And she wanted to live, this was in the fall, she wanted to live past one more Christmas and then plan to die in January. But unfortunately, her disease metastasized to her brain, and she was told that she had a tumor there, which would ultimately usurp her capacity to make this decision, although we didn't know exactly when that would be. And she was then faced with the exact same dilemma that Gloria Taylor had fought for, which is that she was being asked to either decide now to end her life, perhaps prematurely than what she wished, or to live through that last Christmas, but take the risk that she might lose capacity to make this decision and then not be eligible for an assisted death. That was too much for Audrey Parker, and she decided to keep control, and she chose to die in November. But before she did that, she launched a national campaign with Dying with Dignity Canada to beg the government to change the law to allow someone like herself, who was assessed already and approved already, to make a small version of an advanced request with a specific date in mind, such that even if she lost capacity in the meantime, in that extra month, that she would be able to go ahead. And of course, she wasn't able to do that, but her voice was certainly heard. So I just want to tell you again, very briefly, and I'm looking at the time, going back after our law was passed, there was those immediate court challenges, just to know what happened there. The original case, the challenge in British Columbia by Julia Lamb, a young woman with spinal muscular atrophy. She was hoping for in the future to be able to access this care when she felt her life had become intolerable. That court case was not actually heard. It was adjourned when when an expert determined that after the AB case, she may well actually be found eligible for care as the law currently stands. But in Quebec, the Truchon-Gladu case was heard in 2019. And Jean Truchon was a gentleman with cerebral palsy, which was advancing and progressing through his life, and he was slowly losing his independence. He had applied for assisted dying and turned down on the basis of reasonably foreseeable death. And Nicole Gladu was a woman who had post-polio syndrome with the same outcome, had applied for medical assistance in dying and turned down on the basis of reasonably foreseeable. Again, Justice Baudouin gave a very strong, very clear verdict in this decision in September of 2019, when she clarified that the eligibility requirement for reasonably foreseeable death is in fact unconstitutional in our country and must be removed from the law. And then again gave a year before that would be effective. And again, that was delayed. But essentially, on July 11th of this year, that criteria will be lifted from the law within the province of Quebec, where this court case occurred. Importantly, the province of Quebec did not appeal this decision. They determined to let it stand. And the federal government, who also had a stake in this, also determined not to appeal this decision and let it stand. And in fact, campaigned on a national election last year that they would bring the rest of Canada in line with this decision and remove reasonably foreseeable from the national law. Then what happened? Well, the question is, where might we be going? So the government's now promised to remove this clause from our law. So they have held a number of roundtable discussions across our country and heard from a number of important stakeholders about what they feel should be changed. And they opened it up to other possible amendments at the same time once they were making this change. I'm proud to say CAMAP had a very large role in that feedback. And what they've proposed is something called Bill C7. So let me just be explicitly clear that this is not the current law in Canada. This is legislation that has been offered and tabled by our government as a potential change to our law, but it has not become law. So I don't want to spend a lot of time on this because I don't know how much of this will actually ever come through, what will be changed or what will not be. But I'll just give you a glimpse of what it's looking like it could be in our country after July of this year. And essentially, the eligibility criteria for MAiD remain the same except for the removal of one clause, which is that death needs to be reasonably foreseeable. So we take out the end of life regime idea completely. But then what's changed dramatically are the safeguards around what needs to happen next. And essentially, the government has created two tracks for access to MAiD. One is that, ironically, your death is reasonably foreseeable, and the other is when it's not. So if your death is reasonably foreseeable, if you have pancreatic cancer and you are sick, you will now only need one witness to sign your request. There'll be no 10-day waiting period. And what we're calling Audrey's Amendment will be legalized. You can actually make an advanced request once you've been assessed and approved for a specific date and time, even if you lose capacity, that can go forward. So that's a tremendous change. The other track is more complicated. If your death is not considered reasonably foreseeable, although there will only be one witness, you will need to have at minimum 90-day waiting. You'll have to have an assessor who has expertise in your condition. All options to relieve suffering will need to be explored. The clinician and the patient must agree upon this discussion and what's been tried. There's a number of hoops and alleys that need to be maneuvered in order to access MAiD. And again, these may be changed. So I'll just put them up there as possibilities. The other thing that Bill C7 does explicitly is it removes the possibility of psychiatric illness alone as a qualifying diagnosis for assisted dying in Canada. They're clearly wanting to look at this issue more carefully before they allow it. So I'm going to leave C7 there because it's a little unclear. Then, of course, came our friend COVID-19, and everything got delayed. In fact, the second and third readings of this legislation have been delayed, and we're no longer certain that it will be in place by July of 2019. So it's a big unknown of what will happen, though the government has pledged to move forward. I'm going to stop here because of the time. I've been babbling long enough. I do want to just summarize by saying it has been almost 4 years. We got here through patients, through their courage, through their efforts, and specifically through our Charter of Rights and Freedoms. That's really what allowed this to happen. Why did the public support this? Again, because of the stories, because of the patients, because of the people who've come forward. The role of stories in the public, in the news, it cannot be underestimated. As my colleague once said, and I thought this was brilliant, she said, judges read the newspaper. And so getting stories out there is how our zeitgeist changed in Canada, and probably how anybody else as well. How did we get the doctors on board? I'm proud to say that the physicians in our country did not wait for someone else to guide them. We actually took a leadership role right away. We wanted to ensure it would be done properly, and essentially we didn't trust anyone else to help us. And also our patients brought us to the care. We have a rigorous process with safeguards around them in Canada. We're very proud of what we've achieved. At this point, according to our last set of data, of all the annual deaths in Canada, approximately 1.6% of them are by assisted dying. It's not a huge number, it's not a tiny number. There's been no prosecutions of any clinician for malpractice, for abusing the system, for any sort of error. We've got a growing acceptance of assisted dying in our country. We've got national polls suggesting over 84% of our public support assisted dying. And what we're experiencing on a personal level from our patients is a tremendous amount of relief and gratitude, which is sometimes overwhelming and makes this work very, very rewarding.